Good afternoon, everyone. I'm Ernest Lim, professor at NUS Law. Welcome to the E.W. Barker Center for Law and Business webinar on recent legal issues with respect to digital transformation in South Korea. Our speaker today is Dr. Woo Jang-jong, who is an assistant professor at the Korea Advanced Institute of Science and Technology. Professor Jong obtained his doctorate from the University of Oxford, a JD from Korea University Law School, and his master's and bachelor from Seoul National University. Over to you, Professor Jong.
Thank you very much. It is my great honor to make a presentation at the National University Singapore. Today, I would like to address you on the rapidly evolving topic of digital asset, personal. Singapore has made in the area of new technology. Singapore's innovative approach to new technologies has placed it at the forefront of new technologies such as digital assets and artificial intelligence. In this regard, I firmly believe that there are numerous opportunities for Singapore and South Korea to work together and leverage each other's strengths to further advance the tech industry. Thank you for joining me in this presentation. Today, because of time constraint, I will provide a brief introduction to some of the legal issues that South Korea is currently facing in relation to digital transformation. If you have any questions or would like to co-research on these issues, please do not hesitate to contact me at my email, wjjon@kais.co.kr. First, I would like to introduce recent issues about digital assets. With respect to digital assets, I would like to introduce 3 points. The first point is criminal precedents related with digital assets. Second point is the digital asset exchanges regulation. The third point is digital asset market regulation. Related with the digital asset market regulation, recently the Korean Financial Services Commission announced that they will allow a securities token offering. I will explain the recent and important topic of STO in details. With respect to the regulation of digital assets not listed on the exchanges, the current criminal law of Korea applies in terms of fraud, and also the Act on the Regulation of Conducting Fundraising Business Without Permission and Door-to-Door Sales Act applies. And for the exchange regulation, Act on the Reporting and Use of Specific Financial Transaction Information applies. On the other hand, with respect to insider trading of digital assets listed on the exchange and market price manipulation is kind of legislative blank. So it is not clear whether the current Capital Market Act would apply to regulate this kind of insider trading and market manipulation of digital assets. Fraud. So in the past, so many people filed a fraud case to the police or to the prosecutor's office because of they received damages after investing in many altcoins, which has not been listed on the exchanges. And there is also many cases related with the violation of the law, the act on the regulation of conducting fundraising business without permission. So according to this law, if a person would like to conduct a fundraising business, then permission is required. But many digital asset business operators did not get permission, so they have been punished with this act. And also door-to-door act, door-to-door sales act applied. Anyone who creates a multiple level organization with 3 or more consequential subscription levels through the medium of sponsor allowance and uses it to receive money from investors of the company under the guise of purchasing cost and investment for fake virtual currency that has no real economic value and is virtually unusable on the market, violates the door-to-door sales act. The court actually used the expression of fake virtual currency that has no real economic value and is virtually unusable on the market because they were not listed on the exchanges. So there have been so many criminal cases in South Korea. Usually, these criminal cases is for the digital assets which has not been listed on the exchanges. Currently, there is not any regulation about the market manipulation of insider trading about the digital asset. There is only laws regulating the digital asset exchanges. The law is the Act on Reporting and Using Specified Financial Transaction Information. This act is actually made in order to prevent the money laundering. After the global need to regulate money laundering through digital assets, this act has been revised and inserted a provision which defines the concept, the definition of virtual assets. So according to this act, virtual asset means electronic certificates that have economic value and can be electronically traded and transferred, including all rights related thereto. This concept of virtual asset is not defined by using blockchains or distributed ledgers in this act. So actually the scope of this virtual assets under this act is quite large. The effect of application of this act is that if a business operator would like to do a business dealing with a virtual assets, then the business operator should report to the Korean Financial Intelligence Unit. And the requirement of the reporting is as follows. The first requirement is the information protection management system. It's like a computer internet system which prevents hackings. And second requirement is real name confirmation deposit and withdrawal bank account. So at the moment, only 5 digital asset exchanges acquired the real names confirmation deposit and withdraw bank account from Korean banks, from Korean commercial banks. So previously there were about 200 digital asset exchanges, but after the revision of this act, nowadays only five digital asset exchanges can change the digital asset into Korean one. The third requirement is compliance with the financial laws. Those 5 digital asset exchanges are Upbit, Bitsum, Coin1, Kobit, and GoPax. Now, for the third issue, let's see the digital asset market regulation. The issue is whether digital asset is classified as securities. If it is classified as securities, then the traditional Korean Capital Market Act will apply. The Korean financial authorities, it seems that Korean financial authorities apply Howey test of the United States in order to decide whether a digital asset is securities or not. Last year, the Korean Financial Services Commission announced the guidelines for new securities business, such as fractional investment. It is not, this guideline is not about digital assets, but it's about fractional investment in such as the claims for copyright royalty of music. In Korea, there is a company which is called Musical that initiated the business that sells and issues and sells and distributed the claim right for the copyright royalty of a music to different the many investors after dividing the right into several fractions or into several pieces. With respect to these cases, the Korean Financial Services Commission decided that this kind of business model, it should be classified as securities, and it should be regulated by the Korean Capital Market Act, which traditionally regulate the securities. According to these guidelines, the criteria to determine whether it is securities or not is much like the Howey test of the United States. Nowadays in Korea, many fractional investment companies, Musical, for the claims of music royalty, music copyright royalty, and PESA, Solution Blue, and these companies sells fractional investment for expensive artworks. And then lastly, the most important issue with respect to digital assets. I think nowadays the Korean financial authorities, I think, would like to try to regulate the digital assets much similar with securities. In February 2023, this month, the Korean Financial Services Commission has announced a series of measures to overhaul the regulation governing the issues and distribution of security tokens. These measures are intended to enable security token offerings to be conducted within the framework of the Financial Investment Services and Capital Market Act. The key objectives of these measures are twofold. Firstly, to provide clarity on the regulatory treatment of security tokens by setting out principles for determining whether a digital asset classifies as security. And secondly, to establish a regulatory foundation to ensure that security tokens are appropriately issued and distributed in line with current securities regulations. To achieve these goals, the Financial Services Commission has pronounced a number of policy tasks, including providing principles for determining whether the digital asset qualifies as security and providing examples to prevent potential violation of laws and protect investors. Establishing a regulatory framework to ensure that security tokens are appropriately issued and distributed with a focus on three key areas. First, recognizing security tokens as a new form of securities issued under the Act on Electronic Registration of Stocks and Bonds. Second, creating issuer account managers who will directly register and manage security tokens. And thirdly, introducing over-the-counter trading brokers for investment contract securities and beneficiary certificates. Under the current Korean law, such as the Commercial Act and Act on Electronic Registration of Stocks and Bonds, permit the issuance of securities in the form of physical paper certificates and electronic certificates, electronic securities that register rights on the electronic register. The presumption of right is legally recognized for physical security certificates and electronically registered securities, which protect the property rights of investors and ensures stable transactions of securities. In addition to physical security certificates and electronically registered securities, security tokens represent a new form of security issue. The relationship between the concept of securities under the Financial Service and Capital Market Act and the form of issuance under the Commercial Act and the Act on Electronic Registration of Stocks and Bonds can be compared to a food and a serving dish relationship, where securities represent the food and the method of issuance represent the serving dish. This is the comparison of the Korean Financial Services Commission. The Korean Financial Services Commission released a press release, and in the press release of the Korean Financial Services Commission, it is stated that the relationship is like food and dish. So the digital asset is like food. The digital asset is like the dish, only dish, and the food itself is securities. So the food remains the same regardless of the type of serving dish that holds it. So different forms of method of issuance do not affect the nature of a security. It is said by the Korean Financial Services Commission. So it is not possible to use any object as a serving dish to place the food. To protect investors, the method of issuing a security should carry certain legal force and be subject to certain requirements. Depending on the type of food, the appropriate type of serving dish may be different. For the issuance of a typical securities in small amount, the current form of electronic securities, which securities firms centrally register and manage, is inappropriate. Therefore, a new form of issuance is required. By permitting security token offering, which is the issuance and distribution of security tokens, authorities will support the newly emerging trend of securitizing various types of rights and improve the efficiency and convenience in the issuance and the transaction of securities that already exist by utilizing the distributed ledger technology. So, the Korean Commercial Financial Commission announced that even when a security token is issued overseas, the Korean Commercial Financial Commission will be the issuance overseas will be subject to the application of the Korean Financial Service and Capital Market Act if it has domestic consequences through activities such as making offers to domestic Korean investors, for activities attempting to intentionally circumvent the Korean Financial Service and Capital Market Act. Authorities will actively interpret and apply the Korean Financial Service and Capital Market Act, taking into account the purpose of securities regulations and the need for investor protection. It is also stated in the press release of the Korean Financial Service Commission. For securities token issued based on the distributed ledger technology that satisfy these requirements, the same investor protection measures as those applied to electronic securities under the Act on Electronic Registration of Stocks and Bonds will be applied equally. This includes the protection of investors' property rights, with the presumption of rights and assertion of right against a third party under the Act on Electronic Registration of Stocks and Bonds. The Korean Financial Services Commission acknowledges the investors' property right on digital asset is exactly on the a security token. And the Korean Security Depository, KSD, will be responsible for checking whether a security token qualifies for a security. The Korea Securities Depository will scrutinize whether the right can be transferred, transferability, whether each right holder has the same right, substitutability, and whether the issuance is in violation of any law, among other factors. The Korea Securities Depository will also manage the total issuance quantity and compare it to the quantity allocated to investors, ensuring that there are no errors in the issuance of security tokens. The Korean Financial Services Commission also announced that they will introduce issuer account managers. Certain requirements will be able to issue security tokens directly without the need for a security company. But issuers will become issuer account managers and will be responsible for entering the information in the decentralized whitelist of the security company. The authorities will determine the requirements for issuer account managers based on the The authorities will determine the requirements for issuer account managers based on the credibility, expertise, and stability required for entities responsible for recording and managing official records under the law. While entities that do not meet the qualifications will not be restricted from issuing security tokens, they must issue their tokens through a securities company. Also, the Korean Financial Services Commission announced that they will institutionalize small OTC distribution platforms for investment contract securities and beneficiary certificates on non-money trust. The listing market for investment contract securities and the beneficiary certificates can only be operated by entities that have obtained permission to function as an exchange under the Financial Services and the Capital Market Act, similar to other types of securities. These entities will apply listing requirements and the mandatory disclosure of material information, but at an eased level to accommodate the unique characteristics of this market. This market is participated in by many investors with a high transaction volume. The processing speed of distributed ledgers will be limited, and security tokens will be converted into electronically registered securities after listing, utilizing existing transaction payment and settlement infrastructure. So this is the plan of the Korean Financial Commission. I think there is two types of approach, with respect to the digital assets. One approach is a European approach, which make new laws, a set of new laws and regulation like MiCA, in addition to the traditional regulation for the securities. And the second approach is the American approach, is that they try to enlarge, expand the scope of traditional securities and cover the digital assets and apply the same rules to the digital assets. I think it seems that the Korean financial authorities would follow the US approach. Today, the second topic is Personal Information Protection Commission decision against Google and Meta. $100 billion Korean won, approximately 72 million US dollar in fines were imposed along with a corrective order against Google and Meta, which violated the Personal Information Protection Act by collecting personal information, users' behavior information from other companies without users' consent and using it for online customized advertising. Behavior information means online activity information that can identify and analyze users' interests, preferences, and tendencies, such as history of visits and use of websites and applications, history of purchases and searches, etc. Customized and advertisements means online advertisements that are customized to a user by analyzing the user's behavior information. The Korean Personal Information Protection Committee held the 15th plenary meeting on September 14th, 2022, to review the violation of the law by Google and Meta and ordered Google and Meta to correct the violations. So the Korean Personal Information Protection Committee decided to impose fines of 69 billion won on Google and 30 billion won on Meta. This investigation and imposing penalty is the first sanction related to the collection and use of behavior information on online customized advertising platforms, and is the largest fine for violating personal information protection laws and regulation. In Korea, there is a law which is called Personal Information Protection Law. This law is actually follows the approach of the European Union's GDPR. A general data protection regulation. So the level of protection is quite high. Here is the platform, the procedure for collecting behavior information. there is users and platform such as Google and Meta, and these are business operators who actually operate the advertisement and take some portion of the profits from the advertisement. So who actually runs, operates the websites where the customized advertisements is showing. So the platform user identifier and third-party behavior information are transmitted directly from the user's device to the platform, to the Google or Meta without going through the business operator. The business operators such as online shopping malls, media, etc., who use behavior information collection tools distributed by Google or Meta to collect behavior information of their own website and application. Google or Meta publishes advertisements on the business operators' website or application banners and distributing a portion of the revenue to the business operator. When a user logs into the platform from a device, the platform generates a code that can identify the user on that device. This identification can take the form of a user identification cookie for web use, a user identification token for application use, or other similar identifiers. Sometimes the platform will also gather mobile advertising identifiers and link them to the user's account. If a business operator has installed a tool for collecting user behavior information on their website or application, this tool will collect the user's identification code and any other behavior information generated by the user on that device. This information is then sent to the platform, such as Google or Meta, and used to create custom advertisement targeted to the user. The Korean Personal Information Protection Committee has been inspecting the collection and use of behavior information of major online customized advertising platforms, including Google and Meta and other Korean companies, since February 2021, with the support of the Korea Internet and Security Agency. In particular, the platform focused its investigation on whether lawful consent was obtained in the process of collecting and using behavior information of users, visiting and using other websites and applications, behavior information of other companies, and using them for customized advertisement. As a result of the investigation of the Korean Personal Information Protection Committee, it was confirmed that Google and Meta collected and analyzed the behavior information of users, its members, of their services from other companies to deduce the interests of users and use them for customized advertisement without clearly informing users of the facts and without obtaining prior consent. When signing up for the service, Google did not clearly inform about the collection and use of third-party behavior information and used methods such as setting the default to agree while hiding the setting screen. More options. Meta only posted the content to be agreed upon when creating an account, Meta account, a Facebook account, in the full text of the data policy in a form that is not easy to users to understand, and did not inform the user of the specific content of the legal notice and did not obtain consent. Behavior information of other companies is automatically collected during the process of visiting and using websites and applications other than the platform Google or Meta. In particular, the behavior information of third party used for customized advertisement in connection with account information can be utilized across all devices accessed through the user account, and there is a risk of generating sensitive information if continuously accumulated. This is the point why it is critical, according to the Korean Personal Information Protection Committee. As a result of the actual survey of the Korean Personal Information Protection Committee, the majority of Korean users set the platform to allow third-party behavior information collection. Google over 82%, Meta, Facebook over 98%. So it can be said that the possibility and the risk of infringement of the rights of the information subject is very high. In relation to the collection and use of such third-party behavior information, unlike in Korea, so the Korean Personal Information Protection Committee compared the settings when the users sign up the Google service or Facebook, and they found that it is different. They are different. So the settings in the UK is different from the settings in South Korea. So when European users sign up as members, consent is obtained by dividing behavior information collection, customized advertisement, and personal information protection settings so that the user select them himself. In the case of Meta, it recently tried to change the consent method to limit the service. If it does not agree to the collection of behavior information for existing users in South Korea, it was the last year that Meta announced that they will not allow Korean users to use the Facebook service if the users does not agree to the collection of behavior information. But several days later, they revoked the announcement. Meta announced that they would not provide service to Korean users if the users did not agree to the collection of personal information for Facebook and Instagram services. Later, Meta withdrew it. The Korean Personal Information Protection Commission emphasized the violation is serious in that there is a risk of seriously invading an individual's privacy if behavior information collected by identifying users accumulates. The president of the Korean Personal Information Protection Committee said that he hopes that this decision serves as an opportunity to thoroughly protect the right to self-determination of personal information by correcting the unauthorized collection and use of personal information without the user's knowledge in the name of providing free services by the platform, such as Google and Meta. He said that he also hopes that large online advertising platforms will drastically improve transparency in the process of collecting and using personal information and strive to fulfill their social responsibilities in the future. So details of the decision or penalties of the Korean Personal Information Protection Committee is that first, major corrective order in order to collect and use users' behavior information of other companies, notify the user and obtain consent so that the user can easily and clearly recognize and exercise the right to make a free decision. And also, the Korean committee imposed the penalty surcharge in violation of Article 39-3 paragraph 1 of the Korean Personal Information Protection Act, a total of 100 billion won was imposed. And announcement of this position, the decision result was made. And lastly, let's look at the trademark and copyright. There is a quite interesting Supreme Court case about the golf zone case. And then let's think about the effectiveness of arbitration clause in the metaverse terms of use with respect to trademark and copyright dispute. Okay, let's look at the golf zone case. This is the golf zone. Indoor golf simulation game. So you can see the pictures, photos of the real golf clubs. This is a golf zone, indoor golf game, which is called golf zone, made by the company golf zone. The golf zone judgment by the Korean Supreme Court has important implications for metaverse service operators. The case involved golf zone, an online golf simulation game, and the use of real-life golf courses within the game. The court decided that the court's decision suggests that if a metaverse service operator implements an actual building within the metaverse without obtaining necessary permissions, it could be considered copyright infringement. However, it is essential to keep in mind that this decision is specific to the circumstances of the case and may not be applicable to all situations. The legality of using real-world buildings or other copyrighted work within a metaverse will depend on the particular fact of each case and the relevant laws in the jurisdiction. It is essential to note that the production of copyrighted works, such as buildings or other structures, without proper authorization from the copyright holder, is generally prohibited under copyright law. This principle applies to the digital world as well, including metaverse. So the golf zone case before the Korean Supreme Court dealt with a dispute between 4 golf club companies and golf zone, a company that operates an indoor screen golf service. The golf club companies, the 4 golf club companies sued golf zone for damages, alleging that it had scanned their golf courses by drones without permission and reproduced them in 3D images for use in the indoor screen golf game without proper notice. The Korean Supreme Court ultimately found that golf zone's action constitute an act of unfair competition under Article 2, Paragraph 1, Item PA of the Unfair Competition Prevention and Trade Secret Protection Act. There is a law in Korea about unfair competition, which is called Unfair Competition Prevention and Trade Secret Protection. This provision prohibits a company from using another company's reputation, goodwill, or any other advantages gained through its business activities without permission or proper compensation. The court based its decision on the finding that golf zone had used the golf courses of the 4 companies without permission, which gave it an unfair advantage over its competitors in the golf market. The court determined that the comprehensive image of a golf course, which combines topography, scenery, landscape elements, and installations should be considered the result of significant investment or effort by the companies operating golf clubs, separate from the golf course design. While golf courses in a golf club fall under the designer's works, in this case, the plaintiffs were not the golf course designers, but the companies operating those golf clubs. And therefore, their copyright was not acknowledged. The court found that golf zone and the actual golf club were in competition, and that golf zone's act of producing and using 3D golf course videos for a spring golf simulation system, which almost reproduced the images of the real golf club without the permission of the companies operating them, violated the economic interest of those operating companies and unfair competition prevention and trade secret protection act. The Golfton case shed light on the extent of copyright protection for golf courses and the application of the unfair competition prevention and trade secret protection act in the context of metaverse services. In the Golfton case, the Seoul High Court made an important ruling regarding the scope of copyright protection for works of architecture, specifically for golf courses. The court found that the creative individuality of the golf course creator was expressed in each golf course, and that the expressions used were not commonly used or replicated by others, but rather reflected the unique mental effort of the creator. As a result, the court held that the golf courses were not part of the public domain and were protected under the Korean Copyright Act. The court further found that the golf course implemented by its golf club were not simple ideas, but rather works that expressed human thoughts or emotions and exhibited creativity. Therefore, the court concluded that the golf course could be considered works of architecture. The Korean Supreme Court upheld this ruling and recognized that the golf courses at issue in the case were entitled to copyright protection as works of architecture. This decision has significant implications for metaverse services, as it underscores the importance of obtaining proper permissions and respecting the intellectual property rights of creators, including the protection of works of architecture like golf course. In this case, the Korean Supreme Court acknowledged the creatorship of the golf course, but did not find that the plaintiffs who were operating the golf clubs had copyright ownership or had lawfully received the copyright from the actual copyright holders. Although the plaintiffs had entered into an agreement with the designers who were the creators of the golf course and had entrusted them with preparing the golf course blueprint, it is questionable whether the plaintiff could be protected by copyright through legal principles such as implied transfer of copyright or permission to use. It remains unclear whether the plaintiffs implicitly obtained the copyright or a license to use the copyright, even if it originally belongs to the designer. The plaintiffs may have been able to argue that they were entitled to copyright protection under such principles. However, it seems that there is no evidence to suggest that they made such an argument in this case, actually, in this litigation, actually. In the Golfton case, the plaintiffs were not the copyright holders of the golf course. So the issue of copyright infringement was not adjudicated. Instead, liability for damages to the defendant was admitted for act of unfair competition. However, if the copyright holder, such as the designer, of the board to claim damages to copyright infringement against the defendant, then copyright infringement may be occurring. It is important to note that the defendant did not replicate the workflow blueprints as they were, or did not construct actual using them. So corruption judgment also has implications for metaverse service operators to create a virtual recreation of real-world buildings or objects within the metaverse. If these virtual recreations are exact copies of real-world buildings without any transformative changes, they may be recognized as copyright infringement. Therefore, to avoid copyright infringement, virtual recreations within the metaverse must have some degrees of originality or transformative elements. Today's last topic is the effectiveness of arbitration clause in the metaverse terms of use with respect to copyright, trademark, and copyright dispute. The effectiveness of arbitration clause in the metaverse terms of use with respect to trademark and copyright disputes is a relatively new area of law. Traditionally, it has been challenging to arbitrate intellectual property infringement cases due to the lack of contract between the infringer and the right holder, and hence no arbitration clause exists. However, in the metaverse, it is more likely to arbitrate intellectual property infringement cases since the terms of use of the metaverse platform operator include arbitration clauses, may include arbitration clauses. Some include, but some does not. Arbitration can be a useful alternative to litigation in international disputes involving metaverse users from different countries. It can be challenging to enforce criminal laws in foreign countries, and the cost of pursuing litigation in a foreign jurisdiction can be prohibitive. Because in the metaverse, the people all around the world get together, and there might be many disputes between people from a different country. So these kinds of disputes mostly are international. So it is very difficult to regulate with traditional or domestic dispute resolution or the criminal law. Therefore, claiming damages through international arbitration would be a more practical and useful option for resolving intellectual property disputes in the metaverse. The choice of how to resolve an intellectual property dispute will ultimately depend on the specific circumstances of the case and the parties involved. The terms of use of metaverse platform operator are contracts between the metaverse platform operator and the user. They specify that disputes between the user and the metaverse platform operator are to be resolved through arbitration. An example of this can be seen in Article 16, paragraph A of Roblox terms of use. So this is the Roblox terms of use, which is stipulate that dispute subject to arbitration will not be brought to court. The arbitration will follow the consumer arbitration rules of the American Arbitration Association, as stated in Article 16, paragraph D, item 2 of Roblox terms of use. This is so paragraph D, item 2. So arbitration will be overseen by the American Arbitration Association under its consumer arbitration rules. User can find more information at adr.org. So this is the real terms of use of Roblox. So while the terms of use of metaverse platform operator do not get involved in disputes between users, they include an arbitration clause that can be used to resolve disputes between users and metaverse platform operator. If more arbitration clauses are included in the terms of use of metaverse platforms in the future, it is expected that there will be more intellectual property related arbitration. arbitration agreements can be a useful tool for resolving intellectual property disputes between metaverse users themselves as well. However, there are some challenges in determining the effectiveness of arbitration agreements reached through the terms of use of metaverse platform. In particular, it is not entirely clear whether the acceptance of arbitration terms of use can be considered an arbitration agreement between users themselves, not between the user and the platform, just between the users. So user A have dispute with user B. So under this approach, a user would first need to agree to the metaverse terms of use to express their intention to resolve a possible future dispute with other users through arbitration. Other users would then agree to the metaverse terms of use by accepting the previous user's expression of intention to arbitrate towards the users who previously expressed their intention to resolve disputes through arbitration in metaverse terms of use. However, it is unclear whether this expression of intention is sufficient to create a legally binding arbitration agreement. Another challenge is whether the arbitration clause in the metaverse terms of use is valid only for disputes that have occurred after both parties to the dispute have agreed to the metaverse terms of use. This paper argues that the arbitration agreement would come into effect regardless of the time when the users agree to the terms of use. It is because an arbitration agreement can be also made after the dispute has arisen. One potential issue with the use of arbitration in the metaverse is that it may not be available to trademark or copyright holders who are not users of a particular metaverse platform and have not agreed to the terms of use. This concern could lead to a phenomenon in which trademark or copyright holders would try to sign up for membership in all possible metaverse platforms to protect their intellectual property rights. In conclusion, while arbitration agreements reached through the metaverse terms of use can be a useful tool for resolving intellectual property disputes between metaverse users themselves, there are some challenges to their effectiveness that must be addressed. The legal community must continue to study these issues to develop best practices for the use of arbitration agreements in the metaverse. Thanks so much. This is the end of my presentation. Please feel free to email me to wjon@kais.ac.kr if you have any questions about this presentation. Thanks so much.
Thank you so much, Professor John, for your very insightful presentation. While waiting for questions from the audience, I do have one question to ask you, which is this. What is your perspective on the future of digital assets? And do you think that alternative cryptocurrencies other than Bitcoin and Ethereum will be classified as securities and subject to existing securities regulations?
Thanks so much, Professor Lim, and that is actually very important question. The ongoing legal case between Ripple and the United Securities and Exchange Commission.
Professor John, I think you are on mute.
Oh, I'm sorry.
Yes.
Can you hear me?
Yes, I can hear you.
Yeah. The ongoing legal case between Ripple and the US Securities and Exchange Commission, SEC, is of great significance to the future of digital assets. If the US court determines that Ripple's XRP token is a security and should therefore be subject to regulation under the Securities Act. It could set a precedent for other alternative cryptocurrencies to also be classified as securities.
I see.
Yeah. The criteria for classifying cryptocurrencies as securities may vary across different jurisdictions. However, it is likely that there will be increasing efforts toward achieving a unified approach. The Ripple versus SEC case highlights the need for greater regulatory oversight of the cryptocurrency market. For instance, in the United States, the SEC has been taking a clear look at cryptocurrencies and ICOs in recent years, with a particular focus on whether they meet the legal definition of a security. The SEC's approach is guided by the Howey test, like in Korea, which asked whether a transaction involves an investment of money in a common enterprise with the expectation of profits solely from the efforts of others. I read that in Singapore, the Monetary Authority of Singapore, MAS, has also issued guidelines on the regulation of digital tokens. The MAS, Monetary Authority of Singapore, distinguishes between utility tokens, which are used to access a specific product or service, and security tokens, which represent ownership or a financial interest in an underlying asset. The regulatory treatment of security tokens would be aligned with that securities. Ultimately, the outcome of the Ripple versus SEC case will have important implications for the future of digital assets and may influence how other countries approach the regulation of cryptocurrencies. As the digital asset market continues to grow, it is likely that regulators will seek to strike a balance between promoting innovation and ensuring investor protection. Yeah, thank you.
I was quite intrigued by your analysis of metaverse. So I was wondering if you could elaborate on the main argument put forward by Google and Meta in response to the decision made by the Korean Personal Information Protection Commission.
Yeah, thanks so much for the second issue today. It is also very a critical question. In response to the decision of the Korean Personal Information Protection Commission, Google and Meta have argued that, of course, they argued several points, but the most important argument is that the responsibility for obtaining user consent falls on the business operator that requested customized advertisement using behavior information collected by Google and Meta, instead of Google and Meta. Business operators use behavior information collection tools provided by Google or Meta to collect data on their own website and application. Google and Meta then use this information to publish targeted advertisement on the business operator's website or application, and a portion of the revenue generated from these advertisements is distributed to the business operator, as we saw just now. The Korean Personal Information Protection Commission, however, has ruled that Google and Meta must obtain user consent for this type of data collection and targeted advertisement themselves, rather than business operators. Google has contended that business operators, as providers of information and communication services, because they operate the website, should have the primary obligation to obtain user consent. And Meta has argued that it is the responsibility of the business operator to obtain consent because they are the one collecting the user information for their own benefits. However, they have avoided addressing whether they themselves have an obligation to obtain user consent. That is the opinion of the Korean Personal Information Protection Commission. It is important to note that the business operator's obligation to obtain user consent is not a legal obligation. That is the ruling of the Korean Personal Information Protection Commission, but rather a contractual obligation between the business operator and Google or Meta under their own terms and conditions. So the Google and Meta also argued that they have a contract between themselves and business operators. And according to the contract between the Google or Meta and the business operator, the Google and Meta actually requested the business operators to get the consent from their users. But the Korean Personal Information Protection Commission decided that it is just a contractual obligation, it's not a legal obligation. The Korean Personal Information Protection Commission decided that both Google and Meta are legally obligated to obtain user consent under the Korean Personal Information Protection Act. So Google and Meta argued that the responsibility for obtaining user consent falls on business operator, but the business operator is only contractually obligated to obtain user consent. On the other hand, Google and Meta are legally obligated to do so under the Korean Personal Information Protection Act. Yeah, that is the main argument of the Google and Meta and the final decision of the Korean Personal Information Protection Commission. Thank you very much.
Okay, I think I have, given that there's no question in the Q&A box, I do have one last question, and that relates to the use of arbitration. So what are the particular challenges involved in resolving copyright and trademark disputes within the metaverse using arbitration? And what do you think are some of the possible solutions to address these challenges?
Resolving, thanks so much for the question. Also, resolving copyright and trademark disputes within the metaverse using arbitration presents several challenges. One of the most important challenges is whether the arbitration agreement in the terms of use is effective between users themselves, because the terms of use is the agreement between user and the platform. And it is not clear whether such an agreement can be deemed as an arbitration agreement. I hope this can be acknowledged as an arbitration agreement by the court or by the arbitrators. The metaverse terms of use is a contract between the metaverse platform and the user. The arbitration clause can be stipulated in the terms of use to resolve dispute between the metaverse platform and users through arbitration. However, if the metaverse terms of use stipulate an arbitration clause that resolve disputes between users themselves through arbitration, it is unclear, but I hope it could be acknowledged. Even if the terms of use can be regarded as an arbitration agreement, the cost of arbitration could be higher than the amount of the claim. In most cases, suppose that in metaverse, in user A infringes a music copyright of a Korean K-pop star, then but the users or usually teenagers and students don't have enough money, then the amount of claim would not be so much high. So in sometimes the arbitration cost would be more than the amount of claim. I think that kind of disputes would be many. So it is another problem, even though we acknowledge the arbitration agreement through the terms of use. So one potential solution to this problem is to introduce, I think, to introduce an artificial intelligence arbitrator that could conduct arbitration for only small claims. So the challenges involved in resolving copyright and trademark disputes within the metaverse using arbitration include the effectiveness of the arbitration agreement between users and the high cost of arbitration for some small claims. To address these challenges, we could explore the possibility of clarifying the conditions for reaching an arbitration agreement between users and using artificial intelligence arbitrators for some small claims.
Thank you very much, Professor John. I think we have come to the end of the webinar. Thank you so much for the participants for attending this very interesting webinar. Please kindly submit your feedback form. And if you have any suggestions for further improvement, please let us know on the feedback form. So thank you very much, everyone. And thank you, Professor John, once again.
Thank you very much. Thank you.